We always get intelligent debate from is Chris Daw. He's a leading barrister, writer and broadcaster. Chris, good afternoon to you.
Good afternoon, Ian, and it's a very good to speak to you.
Absolutely. Well, I say absolutely good for you to speak to me. I mean, absolutely good for us to speak is my point. Lovely to see you as well, in the shades, in the garden as well. We are here, of course, to talk about...
working out here, Ian. I'm not just sitting
I know.
around doing nothing.
Listen, your quill is never idle, Chris, as we know. This announcement just been confirmed. Andy Burnham has announced he will pause the plan for early release of prisoners. You heard our intro there as well, Chris. This, of course, is on the back of some very serious cases, but I think there's much more to it than just that. I got a feeling I know what your answer is going to be, but, well, firstly, how did we get here with the early release thing?
Well, we got here because our prisons are full and our courts are so overloaded with cases that almost never seem to reach trial. Some of them 3, 4, 5 years in the waiting. People waiting to be sentenced and sometimes sentencing hearings being postponed because there is literally nowhere to put people if they're sent to prison. So that's why we're here. We're here because the government desperately wanted to find ways to free up prison places to put more people in prison.
Which is, I mean, whatever, we'll come back to the putting people in prison in a second. I know it's a favourite territory of ours, Chris, but I mean, that's not a good reason to do it, is it? The fact that they're full. I mean, if you have other reasons, that's fine. But to do it because of they're full doesn't sound like a fairly intellectually solid reason.
No, although, of course, it's a fact that you can only fit so many people in a prison.
True, yes. And so it's a pragmatic thing. It's a
pragmatic approach. And the issue is not so much whether there should be fewer people in prison. I totally agree that there should. And we should make our prisons places where only the dangerous and the violent people who we really want off our streets are being kept. And so, for me, the issue is not so much... So the problem we've got into here is that the PC Harper case, about which a lot of the publicity, and obviously, first and foremost, our thoughts will always have to be with PC Harper's family, who are the real people that we should be focused on, and the concerns that we should have should be to ensure that nobody makes comment which undermines what happened to that family and what happened to that man, because it was extraordinary and it was awful, and a young man died in the prime of his life, and that is absolutely something we should all have at the front of our minds. But the question is this: are we releasing people who are dangerous and physically and potentially violent, or are we releasing people who are not? And if we are not, and that's usually people in the much shorter sentences, or diverting people for non-violent offences, and particularly first and second and very sort of relatively minor offending, if we divert them away from the prisons rather than those who are violent, that makes sense. But if we are releasing people indiscriminately who are violent individuals, and we're releasing them early before they've necessarily followed all of the sentencing, the courses and the programs and the rehabilitation stuff which violent offenders have to do in prison, if we're releasing people into society who represent a clear and present danger to the public, that is wrong. If we are releasing people who are mentally ill or otherwise challenged in their lives, possibly traumatized and abused, who aren't actually violent, and we are diverting them into other services so that they can hopefully recover their lives and lead a law-abiding life, that makes sense. But releasing violent people into society is absolutely insane.
Am I right in saying then, Chris, that the people that would have been earmarked for release in September, this was not a directive from the judge at the time, this has been a subsequent decision?
Correct. So the way that it works is that there are two sort of stages, as it were, to this process. The first is the sentence that the judge imposes.
Yep.
And at the time of that, and I think in this case that the 17-year-olds responsible for PC Harper's murder were given sentences of 13 years for manslaughter, which is a very long sentence for a 17-year-old, it has to be said. And it wasn't murder, it was manslaughter. There was no intent to kill or to cause serious harm, according to the jury that returned the manslaughter verdict. So we have to kind of get that into perspective. But the reality is, what happened is the judge imposes his sentence and says, under the current rules, you will be eligible for release after 2/3 or half or whatever the sentence may be at the time. And then subsequently, the successive governments have brought in early release schemes, essentially to use the Home Secretary's discretion to release people early. And that's always been within the Home Secretary's gift to do that, but provided it's done in a proper way and that there are proper rules around it. So governments have always had the power to sort of increase early releases and manage the flow of capacity in prisons to some degree in that way. I think the difference here is that people are going to be released several years before they would have been released under the judge's sentence, and that I don't have a problem with if they're not dangerous and they've been rehabilitated. I have a problem with it if they remain dangerous. And for me, the issue is this: if you're releasing someone early, you must establish that that person does not represent a risk to the public when you release them. And if you don't, then I'm afraid you're going to see countless cases where people are released early, they go on to commit very serious crimes, and people like you and your colleagues will rightly say, what on earth was the government thinking?
Well, I mean, I'm rather thinking about and I know that the Andrew Harper case is the one that catches everybody's imagination. It was so awful and barbaric. Did you say they had no intention of causing harm?
No, of causing serious harm, because
well, if you drag a man for a mile down the road on the back of a car attached to a rope.
Yeah, but you're trying to argue the case again. The jury decided that they didn't intend to kill him or cause him serious harm. The jury decided that, not me. And once the jury decided that, they had to acquit of murder and convict only of manslaughter. That's the jury's decision.
But so the jury are, to a degree, directed within the parameters of two legal possibilities, right? Manslaughter or murder.
Correct. And it's very straightforward. So I think this is a case where there's been so much misinformation. The jury were asked to convict of murder. The jury were told by the prosecution that the case is that this was intentional killing or intending to cause very serious injury. The jury rejected that, and they accepted that it was a reckless act but not an intentional act. And that's why we have juries. So we have to respect the verdict of the jury. It's no good saying, oh, what about, well, obviously, if you do that, you must be guilty of murder. That 12 members of
I get that, but I would yes, no, but I would disagree with the. I think the chasm in that choice is so wide that I get that the jury couldn't possibly. Was there a premeditated? Did they wake up in the morning and say, "Let's attach a man to a rope and then drive him down"? Of course,
that's not the law of murder. I get.
No, but I'm making the point that it wasn't premeditated, nor did they at the time decide to murder him. However, what happened was barbaric, and it was something they knew. So the jury couldn't possibly convict on the first. I get that, but it doesn't mean that every man on that and woman on that jury thought that there was no intention here. They knew they were going to harm somebody.
Yes, and that's manslaughter. So murder is if you intend to kill.
Yes, indeed.
Or if you intend to cause really serious injury when you commit the act at the time.
But it's nuance, right? It's nuance. What did you think the upshot? You might not have intended to kill, but actually, what do you think the upshot might have been if you drag a man down the road attached to a rope, which is attached to the end of the car?
That's retrospective, and that's the problem. You're analysing the case retrospectively, because at the time, the jury found that they didn't intend to drag him down the street, that they intended to escape, and it was reckless as far as the dragging down the street is concerned. If they deliberately dragged him down the street and knew that they were doing that and knew that he was likely to suffer serious injury, they would have been convicted of murder, they would have been given life sentences, and they would stay in prison for several years to come.
So is your concern then, as a defence lawyer, that we are coming up with the most seductive and emotional case to try and highlight the shortcomings of the early release problem?
No, I don't think so. I think it's fair comment for members of the public, and particularly the family of PC Harper in this case, and members of the press, to use this as an example of how, broadly speaking, people view the system as being too soft on certain types of offenders, particularly those who have killed a police officer, and they did kill a police officer, and no one is remotely on. So I'm certainly not trying to take anything away from the fact that they killed a police officer, and they have got, as I said, a lengthy sentence of 13 years for manslaughter at the age of 17. That is a very long sentence. An adult would have received a sentence of 20 to 25 years probably for the same activity. So it was taken very seriously by the judge. The issue here for me is just a simple one. The public are right to expect that the justice system and our government will keep people safe on the streets. And that means one thing. It means before you release someone early, you must do some sort of assessment of whether they represent a risk to the public. And that happens in prisons all the time. It happens on the parole board when they assess people for release on parole. Those sorts of risk assessments are undertaken all the time. My real concern here is not necessarily the principle of early release, but releasing people who remain dangerous, because that is where the public and journalists like yourself rightly say, if you're releasing people early just to find places in prison because you haven't built enough prisons, or because you've decided decided to put too many people in them without thinking where they'd go, which is the truth, the reality is that, then the public will say, well, you can't do that. That's not right. It's not fair to the victim's family, and that is a consideration, but it's absolutely not fair to the person who might be the victim of next time when that person is out on the streets, when arguably they should remain in custody if they are dangerous. I don't know whether these young men remain dangerous. I don't know. They clearly committed an awful and terrible act which resulted in a man's death when they were 17 years of age. We are now, 6, 7 years later, so they're in their 26, 27 now. 23, 24 now. So that's a big difference between 17 and mid-20s as they are now. Whether they remain dangerous, for me, should be a professional assessment by all of the process that we have for that assessment. Dangerous people stay in prison. People who are arguably rehabilitated and appear not to represent a risk to the public, they should be eligible for early release, but not guaranteed it.
Just a final point, Chris. I'm not against the idea that there are alternatives to prison. There are clearly some people where prison is a complete waste of everybody's time and money. I get that. What I still can't work out, and I'm sure you can't either, is why has nobody... I mean, this idea of tagging and curfews, which I've always thought is the thing waiting to happen, but doesn't happen. Not that I'm aware of. Every now and again, you're on a train, you see somebody with an ankle tag. Went to a garden thing a couple of months ago, and there was a fellow with an ankle tag. I was never going to ask him why, but so you see it once in a while. But the idea that we, use curfews and tags and the like is not really something that's been rolled out in a big way. I would have thought that is the Justice's Department's best friend.
Well,
GoDaddy is the daddy of domains. GoDaddy is the daddy of domains. The daddy of domains. GoDaddy is the daddy of domains.
You're right and wrong. You're right in the sense that the use of tagging and electronic monitoring and other forms of sort of non-incarceration are extremely effective at restricting people's movements, keeping an eye on where they are, and obviously saving a prison place and a vast amount of money as a result, because prison costs about £1,000 a week to keep someone in prison, whereas keeping them on a tag is a few quid in terms of the monitoring and the service. But it is widely used in our criminal justice system. It's widely used for people on bail to ensure that they turn up at court, and it is widely used for people who are released early from prison, and it is used. So be assured that tagging and electronic monitoring, as it's more technically called, is widely used in the criminal justice system. Could it be used for more people who are serving short sentences where really what's the point of 3 months in prison? They'll lose their job, maybe lose their house and all sorts of things for the sake of that. Well, that to me is where the real empty of the prisons comes. Empty the prisons of people who are in for very short sentences, who have committed a non-violent offence, and for whom almost any alternative will result in a rehabilitation which makes them less likely to reoffend. So that's the area. Not dangerous people. I think dangerous and violent people who remain so and have been sentenced to a term of imprisonment should be subject to the sort of assessment that I've described already.
Isn't one of the problems with that, because the principle sounds fine, but many people, you know this better than me, have already gone through multiple non-custodial options and experiences before they've ever been sent to prison. So, in some cases, it could be dozens of different things they've done. So the non-incarceration route didn't work. So judges or magistrates are left with no other option.
Yeah, but that's because the non-incarceration route isn't properly resourced and isn't effective. Probation officers have hundreds of individuals that they have to monitor at once. There are almost no places available for programs. Where there are, those programs are not particularly effective or well researched. So the problem is we have invested a lot more in keeping people in prison for long periods than keeping them from going there in the first place, which is the problem that you've just described. Yes, it's the case that generally speaking, the people you describe who constantly revolving door in and out of crime and justice and police stations and prisons, the vast majority of that revolving door group are people who are addicts, alcoholics, have severe mental illness, or are otherwise in a traumatic life circumstance, and they actually don't mind being in prison. That's the irony of it, Ian. I've represented people, I wrote about it in my book, I've represented people who deliberately went back to prison because actually they just could not survive on the outside because of their circumstances or their drug addictions or whatever it was, and they feel safer in prison. And what does that say about what we're doing with people outside of prison?
Fair point to finish on. Chris, great to see you. Thank you. Enjoy the rest of the day. Chris Daw, barrister, writer and broadcaster.